I want you to understand a rule that most families discover only after the damage is already done. It is called the Medicaid 5-year look-back rule. But that name is misleading. It sounds like a simple review period. It sounds administrative. It sounds like a caseworker checks a few records and moves on. That is not what it really is. In practice, the 5-year look-back is a mechanism that can turn ordinary family generosity into a financial penalty, turn a paid-off home into a recovery target, and turn the last years of a person's life into a legal and financial trap for the people they thought they were protecting. If you are older than 65, if you own a house, if you have savings, if you have children, if you have grandchildren, or if your parents are aging, this rule is not abstract. It is not a footnote. It is not something to think about later. It is a system that must be understood before the crisis arrives. Because once the crisis arrives, many of the best options are gone. That is one of the hardest lessons in long-term care planning. The right move made early can protect the house. The right move made too late may do very little. That is why the timing matters, and that is why the 5-year clock matters. The most dangerous part of this rule is not that it exists. The most dangerous part is that most people do not know it exists until the nursing home bill has already started. By then, the family is tired, the parent is sick, the spouse is scared, the children are confused, the hospital is asking for discharge plans, the nursing facility wants payment, the paperwork is overwhelming, and the state is not asking, "Did you understand the rule?" The state is asking, "What did you transfer during the last 60 months?" That is the structure. It is not based on whether you meant to do anything wrong. It is based on whether assets moved. That is why people get hurt. They were not trying to hide wealth. They were not trying to defraud anyone. They were doing what families do: a birthday check to a granddaughter, a Christmas gift, some help with a child's car repair, a contribution toward college tuition, a loan forgiven because the family was struggling, a car sold to a nephew for $1, a wedding gift, a donation, a small act of kindness repeated over time. In normal family life, those things feel harmless. In the Medicaid system, they can become evidence. The rule does not care how innocent the transfer felt. The rule asks whether you gave away value during the look-back period. If you did, the state may impose a penalty, and the penalty can arrive at exactly the worst possible moment. Let us walk through the machine carefully. Long-term nursing home care is extremely expensive. The source document uses a figure above $108,000 per year. That is more than $9,000 per month. Most families cannot pay that for long. Even families that think they are financially comfortable can be shocked by the speed at which long-term care costs consume savings. A retirement account that took decades to build can shrink fast. A bank account that seemed meaningful can disappear in months. A healthy spouse can watch a lifetime of savings move into a nursing home bill. That is why many people eventually apply for Medicaid. Medicaid is the program that can cover long-term care when a person qualifies financially and medically. But before Medicaid pays, the state looks back. It looks back 60 months, 5 years. It reviews bank statements, property records, transfers, gifts, checks, asset sales, anything that looks like value leaving the person's control. Then it calculates whether the person gave away assets that could have been used to pay for care. If the answer is yes, the state may impose a period of ineligibility. This is where the penalty divisor comes in. The state takes the total amount transferred during the look-back period and divides it by a regional penalty divisor. The divisor is meant to represent the monthly cost of nursing home care in that area. The source document says that in many states that number may sit somewhere around $10,000 to $12,000, though the exact number varies by state and year. If a person transferred $60,000 and the penalty divisor is $10,000 per month, the state may impose a 6-month penalty period. During that penalty period, Medicaid does not pay, but the nursing home still expects payment. This is the trap. The person gave away the money, so the person does not have it. But because the person gave it away, Medicaid will not pay. So the family is caught between two facts that cannot both be solved easily. The money is gone, the bill is due. That is why the rule can feel so cruel. The state is not saying pay a fine, it is saying we will not cover care for a number of months. And during that time, someone must pay the facility. If the family cannot pay, the facility may pursue collection. The house may become part of the solution. The estate may become part of the solution. The children may feel pressure. What looked like a simple gift can become a chain reaction. This is why the IRS gift tax rules create dangerous confusion. Many people know that federal tax law allows annual gifts up to a certain amount without triggering gift tax reporting or tax consequences for most people. The source document mentions a federal annual gift tax exclusion of $19,000 per recipient. So a senior hears that and thinks, I can give this amount to my child or grandchild. It is legal, and for federal gift tax purposes, that may be correct. But Medicaid is not the IRS. That is the key distinction. A transfer can be perfectly legal under federal gift tax rules and still create a Medicaid penalty. These are different systems, different objectives, different rules, different consequences. The IRS may not care. Medicaid may care very much. This is where families make one of their most expensive mistakes. They assume that because a gift is allowed under one part of the law, it is safe under another part of the law. That assumption can destroy a plan. A legal gift can still be a disqualifying transfer. A birthday check can still count. A car signed over cheaply can still count. A college payment can still count. A charitable gift may count depending on the state and circumstances. There is no automatic emotional exemption, no holiday exemption, no I was being kind exemption, no I did, not no exemption. The system is mechanical. That is what makes it dangerous. Human beings think in intentions. Bureaucracies often think in categories. A family says, this was a gift of love. The caseworker says, this was an uncompensated transfer. Those are not the same language. And when you are dealing with Medicaid eligibility, the bureaucratic language controls the outcome. Now let us talk about marriage. Many married couples assume that if one spouse enters a nursing home, the other spouse will be protected. There are protections, but protections are not the same as comfort. The at-home spouse is called the community spouse. The rules allow the community spouse to keep a certain amount of countable assets. The source document uses a 2026 community spouse resource allowance of $157,920 as the maximum amount. At first, that may sound like a lot, but you have to divide it by life. The healthy spouse may need to live for 10, 15, or 20 more years. They may need to pay property taxes, home repairs, insurance, food, gas, medical premiums, dental care, medications, utilities, car maintenance, emergencies, inflation. If the spouse at home is left with only a limited amount of assets, the arithmetic can become frightening. The nursing home may be charging over $9,000 per month for the spouse receiving care, while the healthy spouse is expected to preserve a life on what remains. This is not simply a financial calculation. It is emotional and moral pressure inside a marriage. One spouse needs care, the other spouse needs survival. The state rules are trying to prevent complete impoverishment of the healthy spouse, but the protection may still feel inadequate in real life. That is why planning before the crisis matters so much. Without planning, the healthy spouse may be forced into a smaller and more fragile life. Now, many families believe the house is safe. This belief is one of the most dangerous beliefs in elder planning. They say, the house is exempt. They say Medicaid cannot force a person to sell the house while they are alive. They say the parent can qualify and still keep the home. In many cases, the house may indeed be exempt for eligibility while the Medicaid recipient is alive and using it or intending to return to it, subject to state rules and equity limits. But exempt while alive does not mean protected after death. That distinction is everything. After the Medicaid recipient dies, another system activates, the Medicaid Estate Recovery Program. Federal law requires states to seek recovery for certain Medicaid costs paid on behalf of beneficiaries age 55 and older, especially long-term care costs. The state can file a claim against the estate, and the most valuable estate asset is often the house. So during life, the house may feel safe. After death, it may become the target. That is the trap. The children were told the house would stay in the family. The grandchildren thought it would become an inheritance. The parent believed the home was protected. Then the estate receives a recovery claim. The heirs may be told they must pay the claim or sell the property. If the claim is large, the house may be sold. The family house becomes the state's recovery source. This is why the phrase home exemption can mislead people. A home can be exempt for eligibility and still exposed to estate recovery. You must know which problem you are solving. Eligibility is one problem. Estate recovery is another. A plan that solves only the first may fail at the second. That is why a simple will is often not enough. A will says who gets property after death, but if the property passes through probate and the state has a Medicaid recovery claim, the will does not erase that claim. The will may say the children receive the house, the recovery claim may say the estate owes the state first. That is a very different outcome from what the family expected. This is why relying on a standard will can create a false sense of security. A will may be useful, but it is not a Medicaid asset protection plan. Now, in some states, there is another risk. Filial responsibility laws. The source document mentions 29 states with laws that may allow adult children to be held financially responsible for certain unpaid care costs of parents, and it cites a Pennsylvania case where a nursing home collected a large sum from an adult son. These laws vary by state, and they are not enforced equally everywhere. But the existence of the risk matters. The family often believes the problem ends with the parent's assets. In some states and under some circumstances, the nursing home may try to look beyond the parent's estate. That can create another layer of fear for adult children. Again, the details are state-specific, but the principle is not complicated. Long-term care debt does not always stay neatly contained where families assume it will. The nursing home wants to be paid. The state wants recovery. The family wants to protect the house. Those interests can collide. When they collide without planning, the family is usually the weakest party. Now let us use the kind of example the source document gives. A widow transfers $45,000 to her daughter over a 4-year period. Not one dramatic transfer. A series of normal family supports, birthday gifts, holiday checks, help with a car repair, things she did not consider dangerous. Then she enters a nursing home in month 47. The state looks back 60 months. Those transfers are inside the look-back period. The state adds them up, then the state divides the total by the penalty divisor. A penalty period is created. During that period, Medicaid does not pay. The nursing home still bills thousands of dollars. Per month, the widow cannot pay, the family cannot pay, the house becomes exposed. Then after death, a state recovery adds another claim for care already paid. The family receives a letter, the house must be sold or the claim must be satisfied. This is how a series of ordinary gifts can become a 6-figure family loss. The lesson is not that families should stop helping each other. The lesson is that transfers by older adults must be planned with Medicaid rules in mind. Good intentions do not override eligibility rules. A loving grandmother can accidentally create a penalty. A parent trying to help a child can accidentally endanger the house. That is why education matters before the crisis. Now, there is a strategy sometimes used when planning happens late. It is often called the half-a-loaf strategy. The idea is to preserve some assets by giving away part of the assets and using the remaining part to pay for care during the Medicaid penalty period created by the gift. This can sometimes save something when it is too late to save everything, but it is not simple. It requires timing, it requires state-specific knowledge, it requires an attorney who understands Medicaid planning. It must generally be done before the Medicaid application is filed. Once the application is filed, the strategy may no longer be available. This is not something a family should improvise. It is a crisis strategy, not a casual tool. The fact that half a loaf exists teaches a broader lesson. Even late planning may sometimes help. But late planning is weaker than early planning. Early planning can protect the house and savings more fully. Late planning may only reduce the damage. No planning often leaves the family exposed to the full force of the system. That is the hierarchy. Early planning, late planning, no planning. Each step down gives away options. Now, let us come to the document that matters most in the source material. A Medicaid Asset Protection Trust. This is the phrase families need to know before they walk into an attorney's office. A Medicaid Asset Protection Trust is generally an irrevocable trust. Assets are moved into the trust. The trust, not the individual, owns those assets. The individual may still be able to live in the house if the house is placed in the trust. The individual may be able to receive income from certain trust assets depending on how the trust is drafted. But the individual cannot simply take the assets back as if nothing changed. That is why it is irrevocable. The loss of control is part of what makes it work. After the trust has been properly established and funded for the required 5-year period, the assets may no longer be countable for Medicaid eligibility under the lookback rules, and if structured correctly under applicable state law, the assets may avoid a state recovery. This can protect the house, it can protect savings, it can help preserve an inheritance, but only if done correctly, and only if done early enough. The 5-year clock does not start when you think about planning. It does not start when you watch a video. It does not start when you call a lawyer. It does not start when the trust document is sitting unsigned. It starts when the assets are actually transferred into the trust. The trust must be funded. That is the word families miss. A trust without assets inside it is like a vault with the door open and nothing inside. It may exist on paper, but it has not solved the problem. Funding is the action that starts the clock. This is why the most expensive day may be the day after you should have started. Every day of delay pushes the 5-year protection date further into the future. If care is needed before the 5-year period is complete, the transferred assets may still be inside the lookback that can create penalties. So the map is not a last-minute solution. It is a planning tool. That is why younger seniors should understand it before they believe they need care. If someone is already in a nursing home or about to enter one, the options are more limited and must be handled by a specialist. Now, the source document also mentions ladybird deeds in certain states, including Florida, Texas, Michigan, West Virginia, and Vermont. According to the source, a ladybird deed may help protect a home or avoid certain probate and estate recovery problems. The details are state-specific. A ladybird deed is also known as an enhanced life estate deed. It can allow the owner to keep control during life while naming beneficiaries to receive the property at death without probate. In some states, this can help keep the home outside the probate estate and reduce estate recovery exposure. But this depends on state law. Not every state recognizes ladybird deeds. Not every deed works the same way. And a deed is not the same as a complete Medicaid plan. The important point is that there may be special tools for the home in some states, but they must be used correctly and early enough. Again, ask by name. Do not assume a general estate plan covers this. Do not assume a will protects the house from Medicaid estate recovery. Do not assume an attorney will bring it up if you only ask for a simple will. That is one of the most important practical lessons. Many people walk into a lawyer's office and ask for a will. The lawyer gives them a will. The family leaves feeling protected. But long-term care planning may never have been discussed. Why? Because the client did not ask. Because the lawyer may not focus on Medicaid planning, because a standard will is easier and cheaper, because the difficult conversation about long-term care, irrevocable trusts, asset transfers, look-back periods, and estate recovery never happened. This is not always because the attorney is bad. It may be because the client asked the wrong question to the wrong professional. A general estate attorney is not always the same as a Medicaid planning attorney. The source document recommends a certified elder law attorney, often referred to as CELA. The principle is correct. You want someone whose practice is built around elder law and Medicaid planning, not merely someone who drafts simple wills. This is a specialized area. State rules matter, timelines matter, application timing matters, transfer rules matter, trust drafting matters, estate recovery rules matter. The wrong advice can be expensive. The right advice can protect a lifetime of assets. Now, what should a family do before the crisis? The first step is to understand the last 60 months. Pull bank statements. Look for transfers to family members, look for gifts, look for checks, look for property transfers, look for loans that were forgiven, look for assets sold below fair market value. The source document suggests looking especially for transfers over $500 to family members. That is a practical starting point. The exact treatment depends on the state and the facts, but the point is to know your exposure. You do not want to walk into a Medicaid application blind. You want to know what the state will see. The second step is to speak with the right attorney. Ask specifically about Medicaid planning. Ask about the 5-year look-back. Ask about a Medicaid asset protection trust. Ask whether your state recognizes a ladybird deed or other deed strategy. Ask how estate recovery works in your state. Ask how your home would be treated. Ask how your spouse would be protected. Ask how prior gifts affect eligibility. Ask what should be done. Now, the third step is to fund any trust properly if that is the chosen strategy. Again, the document alone is not enough. Assets must move. The fourth step is to talk to adult children. Many families avoid this conversation because it is uncomfortable. Parents do not want to talk about nursing homes. Children do not want to think about parents needing care. Everyone assumes there will be time later. But later is often when the options are gone. The conversation must happen before the health crisis. It should include assets, title, beneficiaries, trusts, powers of attorney, healthcare directives, and long-term care plans. The fifth step is to understand that Medicaid planning is not the same thing as hiding assets illegally. Legal planning is lawful. Fraud is not. The goal is to use legitimate structures recognized under the rules that requires professional guidance. Do not improvise. Do not move assets casually after watching a video. Do not sign over the house without understanding tax control, Medicaid, creditor, and family consequences. Do not give assets to children if you do not understand whether they can lose those assets through divorce, lawsuits, creditors, bad decisions, or their own financial problems. A trust exists partly because outright gifts can create new risks. Planning is not simply giving things away. Planning is designing control, protection, tax treatment, eligibility, and inheritance. That takes expertise. Now let us look at why most families fail to plan. One reason is denial. People do not want to believe they will need nursing home care. They say, I will never go into a nursing home. Maybe that is true, maybe not. Planning is not a prediction that something will happen. It is protection in case it does. You buy home insurance not because you expect a fire tomorrow, but because a fire would be catastrophic. Long-term care planning works the same way. Another reason is trust in the system. People assume the government will treat them fairly because they paid taxes all their lives. They assume Medicaid will help without taking the house. They assume the house is safe because it was paid for honestly. They assume the children will inherit because the will says so. But the system does not run on assumptions, it runs on rules. If the rules say a state recovery applies, then lifetime taxpaying does not erase that claim. Another reason is confusion between Medicare and Medicaid. Medicare generally covers medical care for seniors, but it does not cover long-term custodial nursing home care indefinitely. Medicaid can cover long-term care, but it is means-tested and subject to asset rules. Many families do not understand the difference until they are already in crisis. That misunderstanding is expensive. Another reason is the cost of planning. A Medicaid asset protection trust can cost thousands of dollars to set up. The source document gives a range from $4,000 to $12,000. A simple will may cost far less. So a senior may choose the cheaper document because the more expensive one feels unnecessary. But if the cheaper document does not solve the real problem, it may be the expensive choice in disguise. A $4,000 to $12,000 plan can feel costly. Losing a house to a state recovery can cost much more. This is the kind of trade-off families need to evaluate, not emotionally, mathematically. Now let us discuss the moral side. Some people are uncomfortable with Medicaid planning because they believe assets should be spent on care before taxpayers pay. That is a legitimate ethical concern. Others believe that a family home should not be lost to long-term care costs after a lifetime of work, especially when the system allows legal planning for those who know the rules. That is also a legitimate concern. The point here is not to resolve the moral debate. The point is to understand the system as it exists. People with knowledge and planning can protect more. People without knowledge lose more. That inequality is real. The wealthy usually get advice early. The middle class often gets surprised late. That is why education matters. A system that rewards planning punishes ignorance. Not because ignorance is immoral, because the rules operate whether or not you know them. Now, the source document says the people who lose everything are almost never the ones who planned. They are the ones who were never told planning was an option. That is the core tragedy. A family sits in a hospital room, a parent needs care, someone signs a power of attorney. Checks start going to the nursing home, the children assume they are doing the right thing. Nobody calls the right elder law attorney, nobody asks about half a loaf, nobody asks about a map, nobody asks about a state recovery, nobody asks whether the home can be protected. Months pass, money leaves, then the Medicaid application is filed. Then the lookback begins, then the transfers are discovered, then the penalty is calculated, then the estate recovery risk becomes visible. By then, options are reduced. This is why the planning must happen before the hospital room. The hospital room is too late for the best version of the plan. Now, what is the larger principle in life and investing? The moment when everyone recognizes the risk is usually not the best moment to prepare. You prepare before the risk is obvious. You build flood defenses before the storm. You buy insurance before the fire. You structure assets before the nursing home. You create legal documents before incapacity. You have family conversations before the crisis. That is how systems survive. The Medicaid 5-year look-back is a time-based rule. Time-based rules punish delay. If you wait until year 4 and 11 months before care is needed, you may not have the protection you thought you were building. If you start at 65, 70, or earlier, when healthy, the clock can run before the need arises. That is the entire advantage. Time transforms the same action from ineffective to protective. A trust funded too late may trigger a penalty. A trust funded early enough may protect assets. Same structure, different timing. That is why timing is the hidden asset. Now let us think about the house specifically for many middle-class families. The house is the largest asset. It is not just financial, it is emotional. It is the place children grew up. It is the symbol of decades of work. It is the asset parents believe they are leaving behind. It may represent most of the family's generational wealth. Losing it to long-term care costs can feel like losing the meaning of a lifetime of work, but the system does not evaluate meaning. It evaluates claims. If the house passes through an estate subject to recovery, the state may claim against it. That is why title matters, probate matters, trust structure matters, deed strategy matters, state law matters. Do not assume love protects the house. Legal structure protects the house. That sentence is cold, but it is true. A promise to children does not protect a house. A will may not protect a house. A memory does not protect a house. A properly designed and timely funded legal plan may protect a house. That is the distinction. Now let us address the spouse again. A healthy spouse staying home may feel betrayed by the system. They thought marriage meant they built assets together. Then one spouse gets sick, and suddenly assets must be spent down. The healthy spouse is allowed to keep a certain amount, but the amount may not feel sufficient for a long life. This creates a painful conflict: care for the sick spouse, survival for the healthy spouse, inheritance for children, rules for Medicaid, bills from the nursing home. All of these collide. Planning early can reduce the collision. Without planning, the healthy spouse may become financially fragile at the exact moment life is already emotionally devastating. This is why elder planning is not only about protecting inheritance, it is about protecting the spouse who remains. The system can be brutal because it compresses love, law, money, and illness into one crisis. You do not want to solve that crisis under pressure. Now, what role do adult children play? Adult children often do not want to ask parents about money. They feel it is disrespectful. They do not want to seem greedy. They do not want to talk about death, incapacity, or nursing homes. But silence can be expensive. A respectful conversation is not greed. It is stewardship. It is asking, do we have a plan if one of you needs long-term care? Is there a power of attorney? Is there a healthcare directive? Is the house titled properly? Have you spoken with a certified elder law attorney? Do you know what Medicaid estate recovery means in this state? Have there been gifts in the last 5 years? Do you understand the look-back? These questions may feel uncomfortable. The letter from the state after death will feel worse. The lawsuit from a nursing home will feel worse. The forced sale of the family home will feel worse. A difficult conversation early is a gift. Avoiding the conversation is not kindness if it leaves everyone exposed. Now, let us talk about documentation. In a Medicaid review, documentation matters. Bank statements, checks, transfer records, deeds, trust documents, receipts, loan agreements, fair market value evidence. If a transfer was not a gift but repayment of a legitimate debt, documentation matters. If a child provided care under a valid caregiver agreement, documentation matters. If an asset was sold for fair market value, documentation matters. If money moved for a legitimate purpose, documentation matters. The state will not reconstruct the truth from family memory, it will look at records. Families often lose because they cannot document what happened. That is another reason to plan early. Good planning creates records, bad planning leaves explanations, records beat explanations. Now, there are also special rules and exceptions in Medicaid planning that vary by state. There may be caregiver-child exceptions, sibling equity interest exceptions, hardship waivers, spousal refusal strategies in some states, annuity planning, promissory notes, caregiver agreements, spend-down strategies. These are advanced and state-specific. I am not adding them as instructions because the source document focuses on the major framework, but the existence of these possibilities reinforces the main point. This is specialized law. You need specialized counsel. A general online explanation is not enough. You need someone who can apply your state's rules to your family's facts. Now let us return to the phrase. The people who are supposed to explain it have a reason to stay quiet. I would state it more carefully. Many professionals are not incentivized to raise a problem the client did not ask about. A hospital wants discharge. A nursing home wants payment. A general estate attorney may provide the will requested. A financial professional may not be licensed or trained to advise on Medicaid. A family may assume someone else will mention it. This creates a gap. In that gap, families lose assets. The solution is to become the person who asks the right question. Do not wait for the system to volunteer every risk. Ask, what happens if I need nursing home care? What happens to my home? What happens after I die? What happens to gifts I made? What happens to my spouse? What happens to my children? What happens if I apply for Medicaid? What happens if I transfer assets now? What documents do I need? What clock starts when those questions force the conversation into the open? Now, there is a psychological reason people delay. They think planning means giving up control. With a Medicaid Asset Protection Trust, there is some truth to that. Irrevocable means you are giving up certain powers. That is why it must be considered carefully. Some people are not ready. Some people need access to assets. Some people have family conflict. Some people should not transfer assets because they cannot trust beneficiaries or trustees. Some people may have tax consequences. Some people may have creditor issues. This is why planning must be customized. The map is powerful, but it is not universally right for everyone. The source document presents it as a key document. It is key, but it must be used correctly. A good attorney will explain what control you lose, what income you keep, what tax effects may exist, how the trust affects basis, who should be trustee, what happens if family members disagree, and how it interacts with state law. Do not sign an irrevocable trust because of fear alone. Sign it because the strategy fits your situation and you understand it. That is the mature approach. Now, if someone does nothing, what happens? Maybe nothing. Maybe they never need nursing home care. Maybe they die peacefully at home. Maybe no problem arises, but planning is about protecting against low probability, high consequence events. Long-term care is not rare enough to ignore, and the cost is high enough to be catastrophic. If the event occurs, the damage can be enormous. That is why doing nothing can be a hidden bet. A bet that you will not need care, a bet that your spouse will be fine, a bet that the house will be safe, a bet that your children will not face claims, a bet that the rules will not matter. Some bets are not obvious because they look like inaction. But inaction is still a position. If you do nothing, you are choosing to let the default system decide. The default system is not designed around preserving your inheritance. It is designed around eligibility and recovery. That is why proactive planning matters. Now, let us summarize the system step by step. Long-term care is expensive. Most families cannot pay indefinitely. Medicaid can help, but it is means tested before Medicaid pays. The state reviews transfers during the prior 5 years. Gifts and below. Market transfers can create a penalty period. During that penalty period, Medicaid will not pay, even though the person may not have the money anymore. The house may be exempt during life but exposed after death through estate recovery. A spouse at home may be protected only up to a limited countable asset amount. In some states, adult children can face risk under filial responsibility laws. Late planning may sometimes save part of the assets through strategies like half a loaf, but it requires specialized timing. Early planning can use tools such as a Medicaid asset protection trust, or in some states, a ladybird deed. The 5-year clock starts when assets are properly transferred, not when you merely decide to plan. That is the map. Once you see the map, the conclusion is obvious. Do not wait. Not because every family needs the same document, not because every person should move assets into a trust, but because every family with aging parents, a home, and meaningful savings needs to understand the risk and the options before the clock runs out. The most expensive mistake is believing you have more time than you do. The second most expensive mistake is believing a will solves Medicaid recovery. The third is believing IRS gift rules are the same as Medicaid rules. The fourth is believing the house is permanently safe because it was exempt while the owner was alive. The fifth is talking to the wrong professional and thinking the problem is solved. These mistakes are common. That is why the rule is so dangerous. Not because it is impossible to plan around, because people do not know they must plan. Now, the final message is this. If you are older, start asking questions. Now, if your parents are older, start the conversation. Now, if there have been gifts during the last 5 years, make a list. Now, if the house is the main asset, understand estate recovery. Now, if your spouse may need care someday, understand the community spouse rules. Now, if you live in a state with a ladybird deed option, ask about it now. If you need a Medicaid asset protection trust, the clock starts only when it is funded. Now is the key word. Planning early is not fear, it is responsibility. The government S5-year rule is not really about looking back. It is about whether you acted early enough before the system looked back. That is the principle if you wait until the nursing home admission. The state gets to look backward at your life while you have almost no ability to go backward and change it. If you plan early, you give your family time, and in this system, time is the asset that protects the other assets.